from the making of the law, from where it does in Parliament through legislation, to in courts through diktat of law, diktat of the judiciary, to executive decisions. And then from there, kind of moving to environmental law in practice and its implementation, which is where perhaps environmental law is unmade and in some ways remade. What does legal protection of the environment, of natural resources, and the interests linked to these resources, whether these are interests of people, of natural entities themselves, or of the nation, as we are often told, national interests linked to environmental protection. What does that really mean? So the initiative at our initiative, Climate, Energy and Environment at the Center for Policy and Research, we routinely are grappling with these issues of environmental law, regulation, governance. And we've been really wanting to have this kind of a discussion on environmental regulation for a while. But really, two things kind of triggered this discussion today. One is, of course, the release of the latest edition of Environmental Law and Policy in India, Cases and Materials. It's the third edition of the book. I think many of us in this on this webinar have kind of grown up reading that book and really excited to see the third edition. Thank you, Mr. Shyam Devan, one of the co-authors who's agreed to be on the panel today with us. And the second is a volume that I had the opportunity to edit, Indian Environmental Law, Key Concepts and Principles, which was published in 2019, and Lovely India has contributed to as well. It has been made an open access volume and is now freely available for download, which is very exciting. It's available on our publisher Orion Black Swan's website. So, what better time to get three scholars on Indian environmental law on a panel together and to discuss Indian environmental law. So I think I'll move on to introducing our panelists for the day. Of course, Mr. Shyam Devan, Senior Advocate at the Supreme Court of India. He specializes in civil, commercial, constitutional and administrative law, and of course has been involved in several landmark environmental cases in India. Dr. Lovely Bhullar, she's an assistant professor at Birmingham Law School. Her research and teaching interests include international and domestic environmental law and policy. She's also co-edited The Right to Sanitation in India. She's published several academic writing, but I think in particular her piece in 2022 on environmental constitutionalism and duties of individuals in India is one of the few pieces on fundamental duty to protect environment. I think it's a fascinating piece. And finally, Dr. Arpita Kodivari is an adjunct professor of clinical law at NYU, where she's doing her postdoctoral research on the role of climate litigation in addressing claims of loss and damage. She's published on deliberative forest governance and environmental lawmaking. Arpita has previously worked as an environmental lawyer advising forest dwelling communities on land rights issues. So now if I could invite our panelists to please deliver their opening remarks, maybe about 5 minutes each, before we kind of set off into the panel discussion. So Mr. Devan, if we could begin with you.
Okay, thanks very much, Shivani, and wonderful to be here on this platform. So I thought I'll just make a few big points as I see them in terms of our architecture as far as environmental law governance in India is concerned. The first thing is, at least the most important thing is institutions. And I think we have to question all the time as to whether we have institutions of governance in the field of environment, whether they work well, whether they deliver, and whether we need new institutions. I think a relatively recent one which we have in terms of an organization is the National Green Tribunal. And I think if that's the one which is going to provide the impetus moving forward into the future, then what are we doing about it, or what can we do about it in terms of improving it? So I would suggest that both in the unmaking and the remaking of environmental law, we have to sort of, remain focused on this issue of creating institutions that can deliver. I think in recognizing that exercise, or in proceeding with that exercise, a very important factor is to also call out institutions which simply don't work. I mean, how much, 20 years, 30 years, how long can you have an institution which just doesn't work? And I would love to be corrected by my co-panelists, but I think our pollution control boards are just completely abysmal failures. And they've had, a run of 5 decades. And I think it's not a question of underperform. They just do not perform at all, at any level, in terms of what the conception is of what they're meant to do. So the big challenge is, what do we do there? And then you have to look at other bureaucracies which we've created in terms of environmental laws. So, for example, you have also the coastal zone management authorities. Now, what sort of institution is that? I asked myself. What sort of organization? Does it have an office? Who are the personnel over there? What is the equipment which we give them, etc.? How do you expect to protect a massive coastline like ours if you do not have any organization which builds itself into an institutional with capacities, economic, technical, the vision to imagine these kind of futures that we want for ourselves? So I think that's something which is very, very important in terms of who is going to deliver in terms of administer the laws which we have and the laws which we will create in the future. So that's one set of points that I thought I'd make. The other set of points I'd like to make is with regard to, do we need to sort of think of something at a higher level, like a constitutional intervention in terms of environment? We don't really have that. So I'd leave you with that thought as well, that do we need some sort of a constitutional body or authority, protector of the environment, or whatever, ombudsman or something, which like your comptroller and auditor general, your election commission, they work at a very high constitutional level, and we seem to be reasonably, or at least a little better at working our constitutional machineries than we do some of our other administrative machineries. And all right, maybe if that's too much, if the bridge too far in conceiving an institution operating at the constitutional level, let me touch upon the need for perhaps a national environmental regulator. But that's also another huge design, something like a national environmental protection agency. Are we just going to leave it to the National Green Tribunal, or do we need an EPA which operates nationally? And then that, of course, involves tinkering with the existing federal structure also to a considerable extent. Because one of my disappointments, not just in environmental law, but across several other bureaucracies, which I see as a practitioner mostly, not an academic, is that there is an enormous propensity for rent seeking under our system. So if you have a government agency which has an option between giving land on, say, freehold and leasehold, they'll any day prefer leasehold for 30 years, because that compels the citizen to come back to that bureaucracy after 30 years and, whatever, grease his way or operate, or whatever the appropriate verb is, moving on to the next generation. And I think much of our licensing in the environmental field as well, unfortunately, is burdened by this kind of rent-seeking exercise in terms of the bureaucracy. And I don't think that's a healthy way of moving forward in terms of governance. And that probably factors in, at least as far as I'm concerned, as a negative, which of course provides an opportunity for reform after reflection. So I think that's my opening bit.
In fact, a few months ago, some of us CPR have done kind of a more extensive study of state pollution control boards in the Indo-Gangetic Plain, in particular on looking at air quality governance. And some of what you were saying in terms of institutional constraints and institutional restructuring that's required resonates very much with the work that we've been doing as well. So thank you so much for those opening remarks. Loveleen, over to you.
Thanks, Shubhani, and thank you, Mr. Dewan. I'm struck by 2 points you made about institutions and kind of center-state relationships. And I'm glad that both of you have used the term remaking of environmental law as well, because I started reading the title as making, unmaking, and remaking. And then I was asking myself, what is environmental law really? Starting from sort of the pollution prevention and control laws, the umbrella Environmental Protection Act, and now with so much more discussion around natural resources law, water law, disaster management law, biodiversity law, land law, isn't that all also environmental law? And the moment we bring all of that into the mix, I think it really does muddy the waters in terms of how many institutions at what level, and how do we manage expertise at the national level with expertise at the domestic level, both in terms of expertise of local government, but also expertise of local people. So this kind of top-down and bottom-up approaches, or is there something in between that we need to think about, is something that we need to engage with quite actively in terms of a critique of the making and the unmaking, and also in terms of where we want to go with remaking environmental law as it stands today. I think this goes without saying that most of what we have as environmental law is quite piecemeal and fragmented. So there is this huge question of whether having one central institution is an answer, especially when we haven't quite seemed to have mapped even the landscape of what is environmental law and who should be involved in what. And then I think from sort of the design aspect, because Shibani very helpfully gave us a brief, so I'm working off that right now, is looking at the question of interpretation. And on one hand, we seem to have quite easily fallen into the 3 pillars of sustainable development approach, where you have people, environment, and the economy. But then we also see how casually and how often one is getting prioritized over the other within the landscape of environmental law. It's environment versus people, where the people are vulnerable communities. It's environment versus the economy, where the economy might come on top. And when it is the economy and the people, we all know how that sometimes does play out. So that's interpretation sometimes, which is, I think, problematic. And then on implementation, there's this huge issue of how the citizenry has to sit as the watchguard constantly. Unless there is pressure from the people, whether through litigation or through petitions, etc., implementation can sometimes stand stuck. So there's that huge issue of implementation. How often can the citizenry do that? Does the citizenry have the resources to do that in terms of financial power, personnel power, and also technical resources? Because we are looking at a discipline that sits at the cusp of law, economics, politics, technology, you name it, really everything. I also wanted to say something briefly about environmental law in my role as an academic now, is how much environmental law teaching and research has evolved with respect to Indian environmental law. And it's a function of, I think, a lot more academics within the country engaging with environmental law. And I think that is something to be encouraged even more. It's also a function of practitioners like Shibani and Mr. Diwan here, who are engaging with scholarship. So thinking about where the intersections between the descriptive doctrinal work and the empirical normative work lies, I think, is quite critical to us thinking about remaking or even unpacking environmental law as it stands. And I think it's also useful to talk about the role of non-academic legal scholarship, the role of think tanks, big and small, and individuals who are not lawyers, but are engaging quite actively with the law, for example, through litigation. So I think these are some of the many things that we need to consider when we are thinking about making, unmaking, and remaking environmental law. I'll stop there for now.
Thank you, Lovely. And I think I thought I had painted a broad landscape. You seem to have broadened it even further. So thank you. Arpita, over to you.
Thank you so much, Shibani, for having me. And I'm excited to be part of this panel. I think much of the points have already been made. One thing to note is most of my points will be sort of rooted in the forest governance landscape and not as broad as sort of Indian environmental law. But perhaps there are some trends which are happening within that geography that can be extrapolated to broader trends of environmental law more generally. I think the first thing that the forest governance and law context struggles with is that the laws are inherently in conflict with each other. So what you have is a set of laws that look at conservation as an exclusionary, governance architecture, and then you have more dynamic laws like the Forest Rights Act wanting to bring in democracy within that very authoritarian framework. And so when these laws are inherently in conflict, you have administrative authorities like the Forest Department having a lot of interpretive power in deciding how the laws get reconciled. And that's where sort of the rubber meets the road when it comes to executive decision making in forest areas. And with that sort of excessive administrative discretion, legal interpretation very often, as Loveleen mentioned, prioritizes the economy over people and rights. And I think CPR has done amazing work, which has been mapping that. I think Kanchi and Manju have been doing that for really long. So that's one sort of trend. The second that I notice is this emergence of sort of a compensatory approach to environmental law. The assumption that you can deforest and then we can make up for it later, especially through the Compensatory Afforestation Act. So this sort of assumption that ecosystems can be recreated is sort of permeating a lot of the decision making at the executive level. And the other trend that you also notice is the multiplicity of authorities. And I think while that exists, I feel, across different environmental law frameworks, in the forest law landscape, it plays a very interesting function. So the multiplicity of authorities creates a lot of chaotic executive decision-making on the ground, but it also throws open a lot of possibilities and legal avenues for forest-dwelling communities to challenge the state. So with a lot of the amendments that we're seeing, at least with forest laws, there's a sense of trying to consolidate that multiplicity of authorities into either like a single window clearance or trying to further sort of go back to the state-center relations and trying to solidify that a lot more and prescribe it a lot more. And that can, in some ways, impact forest-dwelling communities and their abilities to challenge state decision-making, which I guess goes back to the point that both Loveleen and Sham have made, which is around this idea of excessive reliance on the courts, having to go to the courts to address what might be sort of a regulatory failure. And I wonder, I think that's a trend in broader Indian environmental law, but particularly notice that around forests. So that's one. And I'll just close up on the idea of sort of enviro-legal education. I think there's been a lot of engagement of late, and that's really exciting. I think a lot of young law students are energized around wanting to work on environmental issues a lot more. But I do feel like the legal curriculum is ailing, apart from a few exceptions here and there. I think there's a need for the curriculum to sort of match with the current trends of scholarship. As Loveleen was mentioning, I think there's a lot more exciting work happening. And even more emphasis also on the linkages between environmental law, society, and politics. Again, goes back to Loveleen's point that it's not an isolated sort of island of law. It kind of interacts with everything. So it's going to be, I think, interesting times for both enviro-legal education and young environmental lawyers. So just going to watch and see if I can impact it from the sidelines at least.
Thank you, Arpita. I think that is quite an important point in terms of where Indian legal scholarship is. There is a bigger debate of Indian legal academic writing more generally, but I think in environment law in particular, because it's constantly evolving and it is connected to so many other areas that, the scholarship also has to keep up. That's one aspect of the challenge. But the second, as I think, Arpita, you pointed out, our legal curriculum is, I don't think, anywhere in the race right now. I think they're trying to keep up, and I'm hoping new scholarship and new accessible scholarship makes it easier for law teachers and law students to kind of keep up to date and be well equipped once they graduate from law, college, to be able to kind of interact with that, and not just lawyers. And I think, Loveleen, you make that important point. We shouldn't just look at lawyers, because I think environmental adjudication, lawyers are only part of that whole game, and there's so much so many other stakeholders who play such a critical role, and therefore it's important for environmental legal scholarship to kind of reach out to them as well. So I think fantastic points, and I think a great starting point for our panel discussion today. So I kind of open up with the obvious, right? So the Constitution of India and where it stands when it's protecting the environment. And the Indian Constitution often said that Constitution as well as our judiciary, green judiciary, activist judiciary. So the Constitution of India, apart from the deep directive principle of state policy and of course the fundamental duty, the Article 21, the expansive kind of interpretation of Article 21 and the environmental rights, and of course now we have the rights of environment, not just to environment. All of that has meant that there is this expectation that that environmental protection in India has constitutional gravitas. But in practice, we don't really see it as well protected as one would expect. And it's not just environmental rights. I think a lot of recent decisions also talk about other constitutional principles, non-arbitrariness under Article 14, allocation of natural resources, the reference decision, and also right to information, right to public participation, all of these kind of other very significant constitutional principles, they speak to environmental adjudication, or should speak to environmental adjudication. And I was wondering if I could bring in first Loveleen and then Mr. Divan to tell us, where do you think, or rather what role do you think has the Constitution played or can continue to play in environmental protection?
Super, thanks, thanks Shivani. I find it quite interesting how we've kind of started really looking at effectiveness of rights-based approach, and which speaks to this point of the symbolic value, because for the longest time, sort of the backup option has been, well, it has a lot of symbolic value. Of course it does, recognition of rights is really important. But what I find really interesting always is that when it says right to environment, it's not an absolute right. It is confined in so many, many ways that when we are testing effectiveness, we need to remember that it is not doing more than what is absolutely necessary. And it is so strongly wedded to invocation of, say, writ jurisdiction, that in many cases you are looking at whether a particular legislation is being implemented, being complied with, etc. And yes, we've had cases of activism, if you like, where courts have gone further, but by and large, we are playing by the rule book. So I think there is this danger of kind of using right to water, right to environment, right to health as shorthands. They are not absolute. They don't cover everything. And I think that's something to keep in mind in terms of ambition with respect to effectiveness. What do we mean by effectiveness? I also find it really interesting that so much of the discussion of constitution and the environment has focused on rights and rights litigation, because the Constitution, as you said, Shibani, and Mr. Divan was earlier mentioning kind of the state center dynamic, there is so much of it there. The list 1, list 2, and list 3, there is so much environment broadly defined in there. And there is so much of that playing out through legislation, but also through policy. And I think when we are talking about the making, unmaking, and remaking of environmental law, we also need to think about the role environmental policy is playing in that, not just as a supplement, but also as an alternative in many cases, where instead of having, say, a water law, or I do some work on water and sanitation, having a sanitation law, let's go the policy route. And that, of course, has implications in terms of accountability, in terms of access to procedural rights of information, participation, and justice. The other thing which I find quite interesting from the perspective of environmental constitutionalism, and that's something I'm trying to explore in some of my work now, is instead of a rights-based approach, what happens if we start looking at things through the lens of duties of citizens or individuals, as well as duties of the state? Because as we know, India, the Constitution of India does not have a right to the environment embedded in it. It's been read into the Constitution. But the Constitution of India does have a fundamental duty and a directive principle of state policy embedded in it. But what are they doing there? And we do have a tendency, of course, to link the duties of state to that recognized right to environment, but what is the duties of citizens? And I think that's an interesting one to unpack, partly because of this great focus on environmental citizenship and climate citizenship now, this universal notion of citizenship and this democratic notion of citizenship, which is how it's worded in the Constitution of India. And then if you break it down further in terms of who are all these different citizens, and are they rich or poor? Are they men, women, disabled people, children? And I think here, Shivani, you were mentioning the importance of Article 14 from the perspective of the principle of intergenerational and intragenerational equity. We can't not be looking at the relationship between these fundamental rights. And it's also interesting to me that so many times we are thinking about the conflict between fundamental rights like the freedom of trade versus, environmental protection. But again, something you hinted at earlier was the importance of the freedom of speech and expression. Granted, we can question how much of that is still preserved in many situations, but it has been quite instrumental in creating opportunities, not just for access to information, but asking for information to be generated in the first place. There is no right of access to information if there is no information. And there have been many instances where courts have come in and directed government bodies to actually create the data, find out how many lakes actually exist in a particular state, how many of them are polluted. So I think there's a great sort of role for constitutions in this environmental story. And I think sometimes, and while I appreciate the importance of the rights-based approach, I also feel that there is a lot more going on within the Constitution that we need to engage with. For example, the 5th and 6th schedule, and how different parts of the country have different relationships with central government with respect to management of the environment and people's community rights, not just individual rights, which is what receives a lot more attention usually. I'm going to stop there.
Right. Thanks, Lavleen. I think this point of federalism you raise, and I think Mr. Devan, you also mentioned that in terms of the institutional issues, whether we need a central regulator, how do we improve the existing regulators? I think federalism in the environmental context really needs to get a lot more attention. And I hope to come back to this perhaps later on, because as we kind of grapple with climate and these kind of calamitous situations that we're going to be faced with, if we don't deal with these governance challenges, I don't think we can even begin to solve, face these challenges. But over to you, Mr. Devan, and then we can take it.
Yeah, so let me just start on this point, which was mentioned regarding federalism. So let's take that up. So when you look at the overall architecture, and you're all familiar with how our initial national environmental laws came about, the Water Act, the Wildlife Protection Act, etc., before they discovered that, look, Parliament itself had a residuary power, or a specific power, actually, not residuary, by which it could enact laws in implementation of decisions which were taken at global conferences, etc. So that gave Parliament a legislative competence, or a recognition that, look, we needn't really wait for the states to go about this individually. But what's happened? Let's see what's happened. And I think I would like you to also recall or remember that what are our objectives. I think we need to be very, very clear on what the objectives are in terms of policy objectives before we design or redesign laws and unmake laws. Now, take something simple, which we've had on the statute books for more than half a century, which is prevention and control of water pollution. We had even earlier, by the 1960s, we had laws at the state level in some situations. So if we want to keep our rivers and our lakes and prevent water pollution in terms of our water bodies, I mean, surely we need some effective bodies who create vision documents, who have an audit in terms of what the water bodies are, what the water quality in these bodies are. How do we improve it? Do we ensure that, at least there's some progression and progress? Now, when I look around, I find that there is nothing that we have, either at the state level, even your best pollution control boards. I don't believe they come anywhere close to delivering. Now, if you are going to dismantle that, what does it mean in a constitutional perspective? What does it mean from a federal government perspective? It means you're taking away a hugely important area of influence of your states. They may be doing a very bad job, but it's going to require a tremendous degree of persuasion to get the states under our federal structure to yield and give up control. It's another matter as to whether that's a good thing or a bad thing. But one thing is for sure, unless, I mean, there is a discordant note on this. But I really don't think, and I know of no state bureaucracy which is halfway to being competent enough in terms of deliverance. So if we can't do it for our pollution control laws, and we can't do it for our, the Coastal Zone Management Authority, which I mentioned, is also an adjunct of your pollution control board. Within many situations, the secretary of the pollution control board acting as a secretary or whatever, a convener, as far as those boards are concerned. So that's on the environmental, on the pollution control elements. There are obviously other huge complex requirements now in terms of hazardous chemicals, waste disposal, etc., which are also very, very important. We don't have anyone doing the job at the state and the federal level. I think we need a conversation now. Are we really capable of stepping up the competence of all these boards? Why haven't we been able to do it for 50 years? I mean, that's an issue. The other factor I want to mention is that, look, I think at least if you see the promise of or rather the expectation of the early Supreme Court judgments in the field of environment in terms of public interest litigations, the ones which came out in the late 80s and the early 90s. The sense one gets is that, look, we're imploring you, the pollution control boards, to get your act get into shape. We're helping you. We're prodding these, defaulters, etc. We're shutting them down. We're issuing directions, but improve. Now, that hasn't happened for decades, as I see it. That's one aspect. The second aspect is, let's take, I mean, since two of you are in Delhi and perhaps many in the audience are as well. I mean, take an issue like your air pollution. I mean, there's absolutely no political pushback in the political electoral sense at all. This is not on anyone's manifesto in a meaningful manner. It's so that part of the Constitution, which is meant to ensure change through deliberation, discussion, pushback, throw out people who are incapable of governing, hasn't happened for decades in terms of the environment. So then what are you left with? So you're left with, resorting to someone else who's a constitutional function in terms of operating the Constitution. And the easiest one available is your constitutional courts. As it was mentioned, it's cheaper, easier, quicker to get through, file a writ petition and raise an issue with all its faults and limitations. But that's one person at least who has some constitutional mandate who can sort of prod people into shape. But how long are you going to continue with that? So you now have a National Green Tribunal. And I mentioned that in my opening remark as well. I think it's really crucial that we spend some time on ensuring that this institution becomes a much improved institution than from the level at which it is functioning today, in terms of, I mean, I hope the academics here and are doing some studies, but I get occasionally orders which come up from the National Green Tribunal, and they're awfully disappointing. They're awfully. Well, this is the only thing which we have. We've got to make this thing work. The NGT, the Supreme Court is in retreat because there is a National Green Tribunal. But just imagine there's a serious design flaw in your National Green Tribunal Act, and one of the serious design flaws in the Act is that you do not have even one appeal on facts. So my experience of other laws across India is that anyone who can impose even the most paltry of a few lakhs of rupees in terms of penalty, you will get one appeal under the architecture of our other laws on facts. The NGT Act, provides that your National Green Tribunal will be the original authority and the final authority on facts. The appeal to the Supreme Court under Section 22 is only on substantial questions of law. So this means that there's an enormous responsibility on this institution to figure out and get the facts right. Now, what I see, the recent trend, at least a couple of trends which I can share with you, is that they are trying to raise the temperature in terms, because now they also have this, in terms of a constitutional mandate. You mentioned the role of the Constitution. Now we have our top constitutional court, which has said that, look, your function can also be, and they've used the word inquisitorial, with all the challenges which an expression such as that could be. I don't know whether it's a case of loose language or deliberate language. But if you have a single forum, inquisitorial, no appeal on facts, I mean, what are you left with? The judge as prosecutor, the judge as, it's a very, very, it's constitutionally a bit of a conundrum, at least for me, because I'm not really sure as to what kind of animal this is, this creature of statute, the National Green Tribunal. It's sui generis, it's one of a kind, we understand that. But you're inquisitorial, you decide all the facts, and there's no appeal for you from fact. So what I find is at least the NGT in a constitutional in its sort of reinventing itself, it's starting to impose very, very high order of penalty. Very large quantities are being imposed on the basis of turnover, etc. Which many may argue is a good thing, because that's, the pollution control boards didn't did it. At least we've got someone who's, whacking polluters, etc. But is that the question I ask is two. One is study the orders, see the manner in which they come out, examine as to what are the principles that they're applying. Is there anything beyond cutting and pasting from X and Y and Z, which the NGT is doing, and then pushing off, last 3 paragraphs or some sort of conclusion? Or and do we really need to enhance that? Because see, ultimately the credibility of our regulators, including including tribunals like the NGT, depends upon the quality of its decision making, which is not just the final conclusion, but the whole process. And here I would urge you that in terms of furthering our constitutional mandate, since such an enormous responsibility has gone from the Supreme Court and the writ courts and being placed in the lap of the National Green Tribunal, are they doing their job really well, or even, better than the other institutions that which I spoke about? And the final thing which I will mention is, I don't know whether you have seen some of those orders of the National Green Tribunal, where because of the Prevention of Money Laundering Act, this is a serious constitutional issue. The recent Supreme Court of India judgment, we can't forget this. It is so extraordinarily regressive in terms of liberties. I mean, we have a constriction of liberties in our country, which many can argue about in different fields. But in terms of the Prevention of Money Laundering Act, this basic right that we had in terms of reversing, in terms of the presumption of innocence, has been so dramatically constricted by the recent Supreme Court 3-judge judgment in terms of the PMLA. And why have I brought out the PMLA on this platform? The reason I brought it out is you look at the schedule to the Prevention of Money Laundering Act, and you'll find a large number of environmental statutes over there. So you have now National Green Tribunal's orders, which I have seen, which say a copy of this order to be sent to the Enforcement Directorate to take further action if it considers necessary. So you have a prevention of money laundering. These are crucial civil liberties issues, which if we do not correct in whatever manner by writing about it, discussing it, etc., and pushing back, as practitioners in court, the ones who are sort of here in court, and it's a sort of a lowly task, not elevated in terms of analysis, etc., but you're trying to preserve that the interest of your client. So it's a very narrow individual interest, and if you get any kind of gain or purchase from the court, you'll just settle for that. So that's how the law develops and pushes forward in this very narrow incremental way. But if you're going to have this kind of a triumvirate of tyranny in the form of a NGT Act which hasn't got an appeal on facts, a National Green Tribunal which is inquisitorial, a PMLA Act which enlists environmental statutes in its schedule as a predicate offense, an LGT which refers its orders to the Enforcement Directorate. And the Supreme Court said that the presumption of innocence goodbye insofar as these acts are concerned. Where does that leave us as an open society? I think it's a very, very, very serious challenge, which, and lots of work for scholars to move on. All right, maybe I should just,
No, that was
clamp up for a while and let the temperature cool.
No. In fact, I was going to bring you in further, sir, but maybe because I mean, it kind of flows from there in terms of what is the judiciary's engagement on issues relating to environment. I mean, over the years, we've seen our judiciary, not only in India, but from jurisdictions outside of India, have looked to the Indian judiciary and its judgments as something inspirational and relying on principles that our judiciary has incorporated into Indian environmental law. And we see Vellore Citizens is often quote cited, and the Bichri case is often cited for various reasons, the Kamal Nath case. So the question is, in the 80s and 90s, we could see these kind of big judgments coming, laying down the law and what it should be. And I'm wondering whether the judiciary's engagement with environmental issues, has there been a shift? And I'm not talking about the final outcome. We could disagree whether the judiciary should have come down on this side or the other side. But in terms of the substantive engagement with legal reasoning and what kind of legal reasoning, now has there been a shift, if at all, what it is? And the second is this issue of PILs. PILs has always been the vehicle of the economic and economic, social, environmental rights has always been considered to be everyone talks about PIL environmental cases, PILs, which is a different conversation. But PILs are also coming under a critique, not only because they are considered by many to be frivolous or against national developmental ambitions, and but many consider it to be under-inclusive, not representative of interests that should be represented on board. And I'm wondering whether how much of that is true, and if we could kind of reflect on that for a little while. And Arpita, do you want to come in a bit, because some of that has also come from the forest governance point of view, where a lot of, for instance, the Godavarman case has often been criticized as an example of the judiciary overstepping. Again, debatable, but I think it is a good illustration to start.
Yeah, I think much has already been said. So I'm just going to quickly step in here to speak a bit about the Wildlife First case, because that's an interesting example of a PIL not being inclusive and having, a rights erasing kind of jurisprudence emerge from it. And the fascinating thing, or rather the problematic thing with forest governance, as I mentioned earlier, is that contestation over stewardship hasn't been resolved. The laws also continue to perpetuate that conflict to persist. And so with the Wildlife First case, what you see is a constitutional challenge to the Forest Rights Act on the grounds that, the implementation of the Forest Rights Act is going to have adverse ecological impact on the ground, particularly the fragmentation of forest land. And it's filed by a group of nonprofits who firmly believe that the forest governance architecture has to be very particular and exclusionary. So the question then is, if they're not able to mobilize, say, at the level of the legislature or administrative law, you immediately see a lot of different interests go into the courts to try and shape the jurisprudence and change it. And I think Anuj Bhuvania and Amita Bhaviskar's work around this notion of bourgeois environmentalism comes in quite handy to at least reflect on this particular judgment. As far as the Godavarman judgment goes, I think that much has been written about that and definitely has had an exclusionary impact. But the other question also is, if you take a complex conflict like forest governance and situate it in an adversarial forum, what does that mean, both for the law and for the future of that legal framework? So that's been something that I'm still thinking about. I don't necessarily have an answer, but just to conclude, to say that for forest dwelling communities, it's firstly difficult to access the courts, and then you have already this sort of big umbrella of wildlife conservation organizations being able to use the courts effectively. So how does that also play out in terms of who gets to shape jurisprudence and how? Not to say that hard work is not being done by organizations supporting forest dwelling communities, but that disparity is definitely visible.
Thanks, Arpita. Lovely. Can I bring you in on the PIL issue, and as well as kind of if you think you've seen kind of change in your study of environmental decisions by the courts over the years?
Yeah, thanks, Shivani. Just kind of want to go back to Arpita's point, because I think it's a really important one, is about obviously the PIL movement is also heralded because, it just brings so many issues that were happening far away to Delhi. Suddenly, tribal populations were being represented. But, there are studies which talk about what that representation sometimes can mean, not to take away from a lot of excellent work that's being done. And it's happening in many different shapes and forms, where once an issue has been discussed in court and has been resolved, and then it's just a question of implementation. And that's a big question. It can sometimes leave people who are affected in a slightly precarious situation, because the issue is resolved now. What is there to do? You can't go back and ask for the same right again. It's been granted almost. I think there is a huge question of inclusiveness, and in fact, a lot of studies that have looked at impact of public interest environmental litigation, besides, for example, what has happened in Vellore later and what has happened in Bichri. The fact that for Bichri, they went back to court, got another order, and we're still waiting for something to happen. And I think, so there's that huge issue, whether more inclusiveness, because in many ways, those judgments and the way they played out was inclusive. There was a lot more engagement with the local communities. So there's that one big issue. I was also thinking about inclusiveness in the sense of the non-human inclusiveness, because at the outset you mentioned rights of nature. So, so rights to nature or rights to environment and rights of environment. And how are we going to manage that inclusiveness in terms of environmental adjudication is another big issue, because for all the celebration of rights of nature, there are many questions around how do you actually go about, processually working with that right of nature. Speaking of PILs, and also taking on board Mr. Diwan's comments about the NGT, I was also thinking now, especially, with this focus on climate litigation, and now also focus on energy transition litigation, and the idea of the just energy transition, which is about incorporating ideas of environmental justice, climate justice, energy justice. And in addition to that procedural dimension, which would allow us to speak to access to justice, there's a question of recognition justice. And I think especially when we are speaking of some of the most affected populations in the country, there is also this question of how do we consider inclusiveness in judicial fora from that perspective. So not just giving them access to justice, but giving access to their knowledge, access to the information that they have, and how are we going to balance that in the equation in terms of formal science and this, informal, if you like, science, which is as valuable, if not more. So I think we need to kind of start thinking about redefining this concept of inclusiveness. Now, this is very easy for me to say, and I can see the number of difficulties of operationalizing it, but inclusiveness might also be thinking of resources, because to me that's always going to be a big issue. And it goes back to my point about if citizens have to stand as watchguards and have to bring cases of these violations to the court. I've spoken to some groups who've said that we just ran out of steam after a point because we ran out of resources. How many times could we go to court? And it is difficult to go from X place to, say, Delhi. Or, of course, one could argue that now with multiple benches of the NGT, but for some of the problems that Mr. Diwan has highlighted and several other issues, that hardly provides a complete solution. So I think these are some of the things to consider going forward.
So Diwan, if I could bring you in, you've been a practitioner in the Supreme Court and the High Courts for several years now. And do you, in your experience, see kind of any change in the kind of environmental litigation or PILs that are coming to court and what the judiciary's engagement has been?
See, I think the answer is yes. First and foremost, there is clearly a change, and there's a change in approach as well. One of the reasons is because the constitution of our courts, in terms of personnel, is continuously changing in our constitutional courts level. So you will have certain judges who have, a preference for, say, environmental cases. Others may not have, others may have a more development-oriented kind of approach, or economic and hands-off on terms of policy approach, etc. So I think what you saw in the 80s and the 1990s was the baton being passed on from 2 or 3 or 4 judges. That's the presiding judge, who had the 2 or 3 things. One was that, relatively speaking, it was easy pickings in terms of environmental law. Why? Because there was a law and there was a violation, and you were hauling up people because you had people who didn't have a consent to operate. Now, those kind of easier cases are no longer available. I mean, it's not as if it's completely disappeared. But so those were the type of cases. It required, of course, a thrust and vision to get into that area. But so that's one part of the answer, that the questions now have increased in complexity. So the types of violations which are being complained of are much more intricate. They are not the obvious ones, because if you don't have a consent to operate, or you don't have a basic license, you'll now simply be shut down. That much has been embedded in our jurisprudence. The second is, there's an architectural change, which is that you now have a bypass of the constitutional courts, and you now have the National Green Tribunal, and the predecessor institutions which you had before that. So the area where PILs will continue to some extent are, for example, wildlife. And as you know, the Wildlife Act, for instance, hasn't come directly under the National Green Tribunal Act as a scheduled act. So long as that remains, and if there are some wildlife issues, etc., that might continue in your constitutional courts, because it doesn't fall, they can't toss you out and say, go here or go there or go to the NGT. I think on the lack of representation, I think that is a problem in a structured process, such as judicial determinations. Keep aside the environmental cases and the PILs. Let's take a basic issue, say a tax case. Take an interpretation of a rent act, right? You have tens of thousands of such cases, or maybe that's an exaggeration. You have hundreds of such cases across the country which are pending in lower courts. But our hierarchical system is that even though it is not your case which is being decided by the Supreme Court, once the Supreme Court decides that issue, whether it's a tax issue, whether it's a landlord and tenant issue in terms of interpretation of a particular provision under the Rent Act, that becomes binding on all these other courts and in the subordinate cases. So that's typical of most judicial systems which follow a precedent system. You can't have everyone represented and all voices represented through the judicial forum of determination. At the same time, I do recognize that there are, in PILs in particular, where you're affecting a huge swathe of interests who may not be articulated and sufficiently interested in court, there is a judicial pushback. There's a principle, and the principle is that it's a policy matter, it's a government policy matter, and therefore we as judges don't wish to interfere. So ordinarily, a judge, if there's some mere infraction, will not interfere, or your constitutional courts will not interfere. So that's the internal check which we have. But if it becomes something becomes so brazen, for instance, if you have such acute pollution, air or water, and the court says, look, there's no way in which we're going to allow this state of affairs to continue. We are not going to be able to give individual notices, but we will give a general public notice. And if you have an association or something, please come through an association. We will hear you. I think that might be sort of sufficient in terms of the structure and in terms of representation. I don't see any manner. The only choice, it's a bit of a Hobson's choice. Either the court doesn't get into it at all, or if it gets into it, it does it in this kind of representative capacity manner, where some organization represents a whole set of interests and you come forward by engaging this thing. I think I just mentioned wildlife first, but I'll sort of disclose my bias over here because I'm appearing for wildlife first. Okay, so it's an interesting. See, there's one thing which only the Supreme Court can do. So you may take a view which is that look, acts such as this should never be challenged because they're for the greater public good. But there is a challenge on legislative competence. And no one can decide that. The NGT can't decide that. A civil court can't decide that. The question is, can Parliament do this, or does it have to be done by the states? It's only your constitutional courts in your country which can decide this. That's the constitutional mandate. It's either a High Court or the Supreme Court of India. And the issue, the first delicate issue here is that since you're at the end of the day giving pattas or land rights, isn't this an enormous incursion into the rights of states to land and to regulate land, because they're the only ones otherwise who can grant you land right pattas? Okay, so that's a legal issue. I mean, it may not interest anyone at all apart from a bunch of lawyers, but that's a legal handle which will have to be decided by the court, whichever way it takes a call. The second, I think, issue in terms of wildlife first is what the wildlife first, the basic thrust of their petition is that, look, keep everyone who is entitled under the act remain in the forest. Okay. But what about those whom you agree are not entitled to remain in the forest? You, the government, or you, the forest dwellers, agree are not entitled under the law to remain in the forest. At least remove them. So I think, there is something to be said in that regard. Now, when it comes to implementing laws and implementing these kind of judicial determinations, it becomes often a situation where the net is cast too wide, and innocent people or people who are entitled who can't establish X or Y or Z also get caught up. So I'm not for a moment suggesting that this is the best way of resolving it, but this is the way this is the constitutional mechanism which we have. It's not perfect. It's probably pitted with a large number of faults, but this is the manner in which it goes ahead. So finally, at least my sense is there is perhaps a certain degree of judicial fatigue which is setting up in terms of huge, mega PILs for the purposes of administering, etc. So I think the court is very happy to send it across to the NGT rather than take it on. For some things like wildlife, it'll remain. For other things, it may also remain because it was rightly mentioned that, look, there are huge complex problems coming up in terms of climate justice. And I don't think so. You won't have, you're not likely, in my view, to have a Supreme Court judgment, have some large kind of case which looks into the complexities of climate change. I hope not. But at the same time, it's likely that the court might point the direction to the union government that, look, what are you doing about X, or what are you doing about Y? What are you doing about sensitization of, say, if we are concerned at all about ocean levels rising? Have you ensured that local planning authorities across the coastal regions of the country factor in this when they make new development plans, new zonal plans, that there's a possibility that you might just find that 50 and 60 years from now, what you are anticipating or the infrastructure that you're currently constructing may not be of much utility unless you raise it by 3 feet or whatever it is. I don't know. I'm just suggesting that. So you may have some climate litigation in the form of PILs in the Supreme Court, pointing out gaps in existing regulatory structures and inquiring from governments at different levels saying, what do you plan to do about it? But otherwise, I think the task is really quite beyond our present capacities, both at the bar as well as on the bench.
Thank you, Mr. Dewan. I think actually that's an excellent segue into the next theme that I wanted to touch on, kind of moving away from the judiciary and the legal fraternity, because I think that really comes after the regulatory framework fails. And I think, Mr. Dewan, you were kind of referring to that when you said the institutional capacity is not there, for instance, in the Pollution Control Board. And therefore, I wanted to talk a little bit more about regulatory reform, because if we have a stronger regulatory framework, then our dependence on judiciary, hopefully, is less. And so, Arpita, I mean, I know some of your research now looks at climate litigation, and climate is one aspect. But I mean, India is grappling with many other environmental calamities and disasters. And I was wondering if you could tell us a little bit more about how you think the environmental regulatory framework could be reformed in a way that it can adequately respond to some of these issues.
Thank you so much, Shivani. I think it's spot on in the sense that, and I think both the co-panelists have made this point of how this reliance on the judiciary also stems from inadequacy of the law to address some concerns. So there's almost like a need for existing laws to expand and cover a lot of these wider issues. But with my ongoing and very sort of nascent work around climate litigation, I've been noticing that the judiciary can only do so much. And there is something that has to happen within the legislature and within executive decision-making to address these problems. But interestingly, what we're noticing in India is actually a sort of deregulation of environmental laws. And again, I speak to the forest law context, where the Forest Conservation Act there was a proposal to amend it. The forest conservation rules have now gone in the direction where free, prior, and informed consent of forest dwelling communities is no longer necessary. It's changing, again, the scale at which decision making happens. So I think there are two ways to sort of approach the regulatory reform question. One is the direction of travel for the reform. And second, it's what are the questions that continue to plague the idea of legal reform around the environment. So in terms of direction of travel, do we want to go in the direction of deregulation, or do we want to be looking at strengthening laws and strengthening institutions, giving them more teeth, giving them more capacity to enforce, as opposed to sort of creating more centralization of authority, which has been the trend around a lot of the environmental law amendments that have been happening. And I think the bigger questions that remain, even if it is whether the existing legal framework can be used to address the climate question, or whether we need new laws and new institutions, it's, I think, three-pronged. One is the idea of how has environmental law tried to look at distributive justice? And I think that's a constant issue that remains. And I think Mr. Diwan rightly points out with the Forest Rights Act, the question is, if it is turning into a land rights legislation, what does that mean? So is environmental law having to look at inequality and look at preserving the environment? So what does that interaction really look like? And the second, I think, is this issue that I've been focusing on, which is around loss and damage. Because if we're now entering a phase of increasing frequency of disasters and increasing frequency of disasters because and can be attributed to climate change, what does that mean in terms of disaster justice and environmental justice? Are our laws equipped to even address some of that? And especially because accountability doesn't lie with the Indian state, how does one look at accountability and climate liability in this broader context of vulnerable countries and large emitting countries? So that's a question that, again, I'm thinking about. I have no responses to yet, but I hope that sort of opens up some of the issues that I've been sort of struggling with.
Adeline, can I bring you in here? And if you had kind of ideas on what regulatory reform should look like.
Yeah, thanks. So I was involved in some work on the right to sanitation and its implementation. So looking at Swachh Bharat mission and that sort of thing. And what was striking again and again was how public participation was being read as public participation in implementation, not public participation in design. So of course, there's the design aspect, which is EI. We'll have a consultation. We will put it on the website. You may or may not have access to the internet. It may be in English and maybe one Indian language, so you may or may not be able to read it. So there are all of those issues. But keeping that aside, there is this issue of just buy-in then, right? Because you are basically being told you have to construct a toilet. If you construct a toilet, you will get X amount of money. So, so there is a very sort of passive engagement with that policy. And I think that also carries forward into some of the law as well. So there's a question of thinking about how do you create those spaces? And yes, we have plenty of literature which tells us how we should go about doing public participation in decision making. Now, how does that sit then with issues like climate change and other emerging public health emergencies, and the one we've just had, where we have to act quickly, where we have to act decisively? There's an urgent need for action. And I think this is where it becomes really, really tricky. If we are talking about engaging with the public, where do we go with that? And then if you're also talking about a discipline that is looking at science, whether it's economics or it's looking at natural science, then I think that's muddying the water even further in a sense, because of course the best solution apparently is the one where we have everybody fully engaged and we come up with the best possible outcome, but that might take forever. So this tension, I think, is one that needs to be thought of. And I think just to take a step back into the role of the judiciary, actually, and I think there is great value in my view, and I think a lot of people have also said how we seem to have actually achieved a lot more on the procedural indicators than on the substantive indicators. And I think one of them definitely is this nudging government towards, say, developing, say, secondary legislation. Now, we can get into a question of whether the central government should be developing legislation on something that seems like a state subject, and that's a different constitutional question. But there's definitely been that push. So, because the court is no longer dealing with just inadequacies in the law, as Mr. Diwan said, we are looking at huge gaps in the law. And I think that engagement with regulatory processes where you are saying, I can't tell you to make the law, but I can drop enough hints that you move in that direction, I think is definitely a place where the court has, in some sense, influenced lawmaking processes, primary and secondary, but also looked at information generation for public participation.
Great, thank you so much. I'm happy to move into the Q&As, and please, we have an audience. If you would like to ask questions, please put them in the box. And there is one question, I'd like to start with that, kind of rephrasing it. It's a question on the rights-based jurisdiction and kind of recognizing the rights of nature. Mr. Diwan, you've just finished your arguments before the Constitution bench, and I cannot resist but ask you to what do you think about rights of the river, rights of wildlife? What if your thoughts?
See, I just tell you, I think I hinted at that a little earlier, or maybe I mentioned it sufficiently clearly. When you're in court, okay, you're doing your best for your client, right? So you're trying to preserve and protect the interest of your client, and that's your primary focus. So we're really not into some general jurisprudential debate. So often the position and structure one has to take in court is not necessarily something which I might individually but I'll just tell you what. So very briefly, I'll just tell you how this issue arose a couple of weeks ago in the Supreme Court. The Supreme Court has rendered a judgment in something called Animal Welfare Board versus Nagaraj. Nagaraj had lost, I think it was a son or something, in one of the Jallikattu incidents, and he had moved the High Court as far as Tamil Nadu in Madras, and then the matter had bubbled to the Supreme Court under the judgment of Justice Radhakrishnan, where he studies threadbare the Prevention of Cruelty to Animals Act, and he recognizes, in the context of what came up a short while ago, you raised it in terms of a duties jurisprudence. And he says that, well, in this context, it wasn't so much a duties in the constitutional level, but duties at the statute level. And then once he spells out the duties in this judgment, in his judgment, he has to use some sort of shorthand, right? Because you can't keep talking about the duties under the Prevention of Cruelty to Animals Act. So the shorthand he uses is, he uses a concept of animal rights, which he explains fully and says that, look, the reflection of this I would describe as animal rights. And also he goes further to say that there are a certain set of 5 freedoms which are universally recognized in jurisprudence, which the animal world also enjoys. And those kind of freedoms which he articulates are, for example, I'm just giving you one of them, is, for example, the freedom from, say, unnecessary pain and, say, thermal discomfort. So you can't keep an animal in a freezer and things like that, or in very cold weather. So these are the kinds of freedoms for domesticated animals, and he uses it. Now the Tamil Nadu legislature, and then followed by Karnataka and Madras Maharashtra, came in with statutes to this Prevention of Cruelty Act. And now we were now challenging the statute which sought to overturn the judgment. Now in this context, the Supreme Court was pushing us to say that, look, are you recognizing, or is your case premised on animal rights? Did the previous judgment, which was the one I was appearing for PETA in the Tamil Nadu case, which we were seeking to protect. So what was my position as a lawyer? What was PETA's position? Our position was, you must preserve this earlier judgment. And if we had positioned ourselves in that case to suggest that, oh, the Supreme Court of India has articulated animal rights, then we are into a jurisprudential vortex. So ours was a very defensive position or a conservative position, saying that the Supreme Court has done none of that. Because if we had said that, yes, they have now recognized animal rights, this was a panel of 5 judges, they would be very happy to overturn it and said that there's no reason and logic for that kind of, jurisprudential leap. So, because there are huge and complex issues in terms of this. So, therefore, when we are talking about nature rights and animal rights, the way I would look at it is this. I would suggest that, look, this is really something first and foremost, because it has such enormous impacts across the board, whether it is rights for a river or whether it is rights for a certain, members of the animal kingdom and sentient beasts, etc. It has huge cultural impacts. It has huge political impacts. It has huge property ownership and other types of impact. So this is really something which the legislature should be doing, and not so much a court. So that is one area which I would flag, and I would say that but at the same time, is the court to remain completely quiet and silent? So I think there may be some situations where you might give standing to a river, you might give standing to a particular species, say, which is on the brink of extinction, and say that, look, we are appointing X or Y or Z as an amicus in the matter to help the court because this species, supposing you've got a certain ecosystem where you've got the last free-flowing river and everything else is completely dammed, etc., etc. All right. You may have a certain species, the species of fish, you may have a certain bird, you may have a certain animal which is just local to this area, and you have a large developmental project coming up. I can quite see on a case-by-case basis a court saying that, look, we need a human agency here to represent as best he or she can the interests of this species. Whether it is, some it could botanical species on the brink of extinction, or a tree, a river, a flowing river, whatever. I think that incremental, I think our jurisprudence would be able to recognize that. It would be able to accommodate that. It would not mean that we are confirming and we are conferring rights across the board on animal kingdom or on inanimate objects. But that is something which I see is possible under our jurisprudence, just through judge-made law and through judgment deliveries. But I don't see, and I don't think it proper for a wholesale conferment through the judicial process. I think that is something really for the legislature to look at.
Oh, thank you, Mr. Devan. So lovely, over to you. There's a question about environmental duties, and that's something that you have written about. And so the question is, how do you perceive the emergence of the state's duty to protect the environment through the emergency era for Second Amendment? And what does it mean for democratic legitimacy of environment protection? If I could just add, I think there's kind of been politically this move towards citizenship, duty bound kind of argument on protection. And maybe perhaps not as much in the environmental context, but I think it does become more relevant now. So just some of your reflections, please.
Thanks. So just to kind of go back to sort of history, and the amendment took place in 1976. 1972, Mrs. Indira Gandhi went to Stockholm, a big international conference. Stockholm Declaration said a lot of wonderful things about our relationship with the environment. And there is some anecdotal evidence to suggest that there is a continuation from that encounter to her interest in the environment, and then of course the movements taking place domestically that led to this. Now, in terms of democratic legitimacy for environmental protection discourse, obviously there is value in having that, because we see that we don't have a constitutional right to the environment guaranteed. It's been read into our constitution. And that duty of the state, which is a non-justiciable duty because it's a directive principle of state policy, somehow that creation of the relationship between the right and the duty. Now, we can criticize that from a sort of more conceptual perspective, but it did create that opportunity or that push for more legislation on environment. For example, we do have, well, more law. I mean, some people might argue that at one point they used to say we don't need more laws on environment protection in the country. We need to just implement the ones we have. Now, of course, I think things might have moved from there. So I think there is an element of legitimacy to that duty from my perspective. But coming now to Shivani's question of where do we go from that duty of state to duty of citizens? And I think this is where the legitimacy question becomes even more interesting, because the Constitution says quite clearly that the directive principles are non-justiciable. The Constitution doesn't say anything about fundamental duties in the sense of justiciability or non-justiciability. But then if we go back to say that the Constitution is the document of the people addressed to the state on how the relationship between the state and the people is to be managed, it does seem quite problematic to say that don't ask for your right before you perform your duty, citizen. And first you perform your duty, then you ask for your right, and then the state will do its duty. And that to me is clearly contrary to ideals of democratic legitimacy. I'll just leave it there.
So that sequencing is becoming problematic. Spot. Arpita, there's a question here about how to reduce the scope of undue discretion to the executive in applying the Indian Forest Act 1927 over the FRA, particularly in protecting the rights of indigenous tribes. Did you want to take that?
Sure. So it's a tricky question, because I think the institutional history of the Forest Department is such that it's, some describe it as sort of a colonial legacy that we've inherited, and then the post-colonial Indian state has sort of carried on with that, legal infrastructure. And a lot of complexity also around, the role of the Forest Department vis-a-vis the wildlife bureaucracy and how they interact, and then the role of the district collector as well. So I think it's discretionary power under the Indian Forest Act in that sense. It's in multiple places. And it's also a question of how wide that discretionary power is. So to give you an example, what the Indian Forest Act enables, just like off the top of my hat, is sort of top of my head, sorry, is forest offenses, right? So if you look at just the section on forest offenses, what it does is the Forest Rights Act recognizes those as rights. So simple question then is, if the right has been recognized within the FRA, for instance, the right to graze or even just right to minor forest produce, and that gets categorized as an offense under the Indian Forest Act, how does that get reconciled on the ground? And how do we understand a situation where that reconciliation is possible, where communities and the Forest Department can enter into dialogue? And I think that really has happened in a very few cases. I think this the biggest issue there with discretionary power being checked is allowing communities to have an equal say in forest decision making. And we've got progressive laws around community-based conservation, whether you look at the Wildlife Protection Act, provisions around that, or within the Forest Rights Act as well. So the idea there is, how do we start to amplify some of those governance approaches? And not to say that the state should completely retreat from regulation, sort of regulating forests, but rather looking at what does a shared governance framework actually look like in these areas. And that's where I think this discretionary power can be checked. And I'll just stop with the last point, where it's fascinating that when the Forest Rights Act came into being, the interpretive clause says that it needs to be read along with the other set of forest laws, but really no interpretive guidance on how to read them together. Because I think essentially that's what we need in terms of discretionary power and decision making going forward.
Thank you, Arpita. Yeah, Mr. Devan, if I could bring you in here and just threading a few of the questions together. There has been a move towards centralization of environmental decision making. And some of the recent proposed amendments to the Air Act, Water Act, EPA, all talk about this fund. They all talk about a new adjudicatory authority mechanism. We are looking at the carbon credit mechanism that's come in. It's all, there's kind of a, I mean, Arpita talked about deregulation, but we also see kind of a trend towards centralization of some of these significant decision-making powers. And do you think that's kind of the right road to reform, in your opinion?
No, I really don't know. I don't have a view as such on that. I am looking at it in terms of competence. Okay, do we have competence at the local level? Do we have competence at okay, let's I use the expression local. Take a city plan. All right, have you studied the city plan, the latest city plan for master plan for New Delhi? What does it say about climate change? Have you seen the latest 2034 plan for Mumbai? What does it say about climate change? Now, if your most important cities, town plans, which are looking at projections for 15 years and 20 years, are completely ignorant on this kind of an aspect, you're going to have to build capacities. Now, how are we going to build capacities at the ground level in sensitizing our planning process, let's drop planning, our decision-making process to combat this? So one is, as was mentioned, something in terms of, I'm sorry about this, in terms of, I think there's a slight.
Yeah, we can hear you.
Yeah, you can hear me? Okay,
yes,
we just go with this
because but it's a different, but we can see you as well.
It's a different camera. All right. I don't know what's happened here, so I'm just going to try and not touch anything at all. Sorry about this. So anyway, the point is that if I was saying competences and capacities. So if we are going to look for competence and capacity, where are we going to get it? We've got to create it at the local level. So I'd be very happy if we could have a decentralized decision making alive to the challenges over the next 10, 15, and 20 years. I'm not some great votary of centralization, but at the same time, I do feel that perhaps the time has come when we're able to renegotiate our, the constitutional architecture for the purposes of administering your basic environmental laws. And if your PCBs haven't worked for whatever reason, maybe we need an Environment Protection Agency. Maybe, what is your Ministry of Environment and Forest doing today? It is essentially acting as an Environment Protection Agency at many levels without being actually a Section 3.3 authority. If you have a Section 3.3 authority under the Environment Protection Act, created with a national mandate, perhaps we'll have some accountability, supposing we'll build an institution in that manner, instead of an MOEF, which we don't know, what is happening within its within the corridors of that. So that's one area. And the other other point which I would suggest in terms of, again, decentralization, is that if EPA is one, I did mention an intervention at the constitutional level, perhaps, is another kind of thing, which is centralized at a certain level. But then you have a centralized authority which provides the learning, which provides the capacity building at the lower levels. I think if we're going to hope for a bottom-up learning, I don't know if it's going to come anytime soon, and certainly not within the kind of schedules which we're looking at, which we're looking at in terms of a decade or whatever, 2030 SDG goals and things of that sort. So I'm not quite sure we're ready for that as a society.
Lovely. One question to you. I mean, you've looked at water pollution much more, but there's a question about air quality, and I think the governance structures are similar. So that there is a move now towards market-based mechanisms, and now we have the carbon credits coming through. Well, at least there is a move towards that. Do you think that moving away from command and control, and in that sense, somehow moving away from the existing SPCB, CPCB architecture, and moving more towards kind of an incentive-based mechanism, do you think that is a possible reform that we should?
Yeah, I'm going to give my diplomatic answer to this, which is that I don't think you can move away from one to the other. And I don't think you can move from one to the other in its entirety in a country like ours. You need a regulator of sorts. I do believe that there is an argument to be made for expanding capacities of these regulators, because one of the problems with the current regulators like the PCBs also is that they just have been dumped with everything. They have to do everything under every environmental law that we have around. And if we're going to have more of those laws with climate change laws being pushed, hopefully it's not the pollution control boards, but we have a real problem. The thing about market-based instruments is that I think we need to spend a little more time understanding where they work and where they don't work, because there are plenty of examples of all the caveats that make them work. Without undertaking some study, and I think this is where not just homegrown talent in terms of environmental law scholarship, but we also need talent in terms of environmental economics to kind of do that kind of examination. What happens when you bring MBIs into a country like India? But to go back to your question, the answer is no, we don't move from one to the other. We might have to think about how they might work with each other in particular circumstances.
Thank you, Lavleen. Well, I think we are drawing to a close for today's panel discussion. Thank you so much, all three of you. I think lots of food for thought, a lot of discussion and deliberation, and I think we managed to cover several topics. I wasn't sure we'll manage to, but we did. I do hope we all continue kind of engaging, because I think legal scholarship in India, there's so much scope for writing, but also more importantly, and I think Mr. Devan would agree, so much scope for academics to speak to practitioners, for practitioners to speak to academics, and not just in law, but in other areas, lovely, like economics. People need to kind of come in and, all of us need to feed off each other's experience and expertise. So thank you so much, everyone who've stayed on with us, and thank you so much to the panelists as well.
Thank you, Shubhani. Thank you, Lavleen. Thank you, Arpita.
Thank you.